Hello everyone, welcome back to day 16 of Polity Daily Drill. And I hope you're aware that today UPSC announced the results for the 2023 Civil Services Examination. And now, as the country would celebrate the success of all those who have triumphed in the examination, let it fuel your inspiration as well. For those still on the journey, remember that persistence is key. Keep striving, refining, and believing. Your dedication will carve your path to success. So let's begin. First question: which of the following statements is correct? As per the Constitution, the tenure of Rajya Sabha members is 6 years. Now, so as you know, that the fact is actually correct. The tenure of Rajya Sabha members is 6 years. However, the question is whether this fact is mentioned in the Constitution or not. And just to clarify, this is not mentioned in the Constitution but under section 154 of RPA 1951. Hence, this is wrong. Second one, the minimum number of ministers in the Council of Ministers at the center must be 12. Again, the fact would have been correct if this word was states. Why? Because as per Article 164, the maximum number of ministers in any state would be equal to or less than or should not exceed 15% of the total strength of the Legislative Assembly. And for states, there is also a minimum set, that is 12. However, for center, there is no minimum, making statement B also wrong. Coming to C, it is mandatory for the person to be an ordinary resident of the state to be eligible for governor's nomination to the Legislative Assembly. Now, this is a problem. Why? The statement was absolutely correct and would have been completely correct had we used the word council. However, number one, there is no nomination as of now for the legislative assemblies. Why? Because we had the concept of Anglo-Indian nomination, but sadly, since 2020, the provision was not renewed. Why? Because it was felt that the population of Anglo-Indians was too small to warrant to merit any nomination, any representation in the Lok Sabha as well as the assemblies, and hence the provision expired. So when it comes to councils, I'm sure you're aware that 1/6 of the number of members of the council are nominated by the governor, and to be eligible for that nomination, you must be an ordinary resident of the state. So that's for the council, not for the assembly. Statement is wrong, hence D must be right. There is no ground mentioned in the Constitution for the removal of the Vice President. Absolutely correct. Article 67, Clause B does talk about the procedure. Yes, of course, the voting criteria. But what is the reason? That is not mentioned in the Constitution. So right answer is D. Moving on to question number 2. Consider the following statements regarding enactment of the budget. Department of Revenue is responsible for the preparation of the budget is a wrong statement. Why? Because the budget is prepared by the Budget Division, which comes under the Department of Economic Affairs, not the Department of Revenue, which is under the Ministry of Finance. So 1 is wrong. Second one, passing of an appropriation bill completes budget session. This is also incorrect. Why? Because the passing of the finance bill is what completes the budget session. The ultimate objective is to pass the finance bill. So the budgetary exercise gets completed with the passage of the finance bill and not the appropriation bill. This finance bill is primarily related to the revenue generation of the government, right? So this would mean taxation proposals. So once the money comes, then the government can, over the course of next 1 year, invest the money, spend the money properly, accordingly, and as far as the appropriation grants are concerned. So 2 is also wrong. Third one, the term budget used in the constitution has been dealt with under Article 112. See, Article 112 does talk about the concept of what we know as an annual financial statement. However, does it use the word budget? Not really. The term is not used, and that's the reason why you might find that we are prominently trying to replace that word budget with bahi khata nowadays. Hence 3 is also wrong. How many statements are correct? D. None of the statements are correct. Moving on to question number 3. Consider the following statements regarding Election Commission of India. The removal of members of ECI is the same as that of a Supreme Court judge. So yesterday as well we had seen a similar question about the Chief Election Commissioner. Now we know very well that the Chief Election Commissioner's removal is the same as Supreme Court judge. However, the other election commissioners, their removal is not same as that of Supreme Court judge. In fact, Article 324 Clause 5, which talks about the removal of CEC, is completely silent on either the ground or the manner, the process of the removal of the other ECs. All it says is that the other ECs will be removed only on the recommendation of the CEC. That's it. So 1 is wrong. Second one, as per the constitution, the election commissioners have a fixed tenure of 6 years or until they reach the age of 65 years, whichever is earlier. Now this fact is again correct. Of course, the election commissioners, including the CEC, have a tenure of 6 years or the retirement age of 65, the age of superannuation. However, this fact is not mentioned in the constitution. Why? Because it's a statutory provision. This fact is mentioned in a law. The CEC and the other ECs, Appointment, Conditions of Service and the Term of Office Act of 2023. In fact, this law replaced an old law of the 1990s. Hence, this statement is also wrong. Why? Because the fact might be correct, but it is not mentioned in the constitution. This would mean which of the statements are correct? None of the statements here mentioned for us is correct. Moving on to question number 4. Consider the following statements regarding the doctrine of basic structure. First one, the term basic structure was added to the Constitution of India through the 44th Amendment Act of 1978. I hope you know this statement is incorrect. Why? Basic structure is not mentioned in the Constitution. It is what we would call a judicial innovation, right? So in the year 1973, we had a landmark judgment, the Keshwanand Bharti case, in which Supreme Court came up with this concept of basic structure. 1 is wrong. Second one, it does not apply to laws which are placed under the 9th schedule of the Indian Constitution. Now the purpose of 9th schedule, which was added through the First Amendment Act of 1951, was what? Was to make sure that there is complete immunity from judicial review of the laws placed under this schedule. However, the Supreme Court has clarified later on in the year 2007 in the I.R. Coelho case that all the laws placed in Schedule 9 after the date of the judgment of Keshwanand Bharti, which is 24th of April 1973, all those laws will be open to judicial review. So now the basic structure is applicable even to laws placed under 9th schedule, and if you place a law under 9th schedule, it can be reviewed judicially if it violates basic structure. Second statement is wrong. Third one, Bangladesh is the only country apart from India that has recognized the principle of basic structure. This is wrong. There are various countries which have a concept like this. Germany has a concept like this. In fact, Uganda has directly borrowed a concept from the Keshwaran Bharati judgment. So Bangladesh is not the only country. There are other countries as well which do not entertain or allow certain very essential features of their constitution from being modified. So how many statements are not correct? All the statements are not correct. C is the right answer. And the last question for today, the fifth one. Consider the following statements with reference to the constitutional provisions related to the seat of the Supreme Court. Seat of Supreme Court is mentioned under Article 130. So, the Supreme Court shall sit in Delhi or any other place. Is that correct? Of course it is correct. Article 130 allows for the Supreme Court to sit in Delhi or any other place. Coming to statement number 2. The seat of Supreme Court shall be decided by the Chief Justice of India. This is also correct. Now the third one. The approval of the Parliament is required before making any changes to the seat. Now herein lies the problem. The approval of not the Parliament but the President is required. So with the prior consent of the President, the CJI can also sit in other places, or CJI can ask the Supreme Court to sit in other places, right? So it is the President, not the Parliament. 3 is incorrect. Which of the statements given above is or are correct? Only 1 and 2, making D the right answer. That is it for today, guys. Let's meet tomorrow. Till then, that's all for me. Jai Hind.